Okay, let's get started. Thank you everyone for putting getting the chat activated. Sorry it took a second. Hi, my name is Anurima Bhargava. I am here with many hats on. I am a very proud part of the Crimson Courage and Democracy House communities who have really continued to create spaces where we can engage on what's been happening in higher education around the country, in particular the federal government attacks on higher education. And I'm here with three extraordinary colleagues who are experts in higher education and in civil rights and in the First Amendment. And so we wanted to take the time today to do a couple things. First is to thank all of you because there was a decision that came down last week on Wednesday on the 3rd of September from Judge Allison Burroughs, and in many ways, it was a slam dunk victory for Harvard, and a slam dunk victory for educational institutions around the country, because that's so much of the reason why Harvard and so many others stood up to fight in the case. And so, but I want to just start by thanking all of you because I know that we've seen some heartbreaking moments in the last many months around higher education and around the protection of academic freedom and institutional independence and the safety and environment that students are in. And so it's been a really difficult time. We've seen presidents resign. We've seen students not be able to come and access their education. We've seen people who are fearful of being able to come and speak and teach and think and voice in the way in which higher education should certainly always be about. And so to be able to come together today and celebrate a win is a big deal. And we didn't want the time to pass without actually being able to talk about the decision and what it means for all of us, not just the lawyers and the folks at universities and colleges and schools around the country, but all of us who care so deeply about the mission and the values and the freedoms that education allows us. So, so with that, I'm just going to talk a little bit about the decision and then turn it to all of us. We're gonna spend some time breaking down the decision. Please do me a couple of favors. So the first thing is we're going to put some of the decision and other information in the chat. So you'll have a chance to look at some of that. The hope here is that we'll take what was an 84-page decision and make it a little bit easier to digest and more fun. And then if you have questions, please put them into the Q&A, and we will have a significant amount of time for questions. This webinar is going to last an hour, but we will have time for questions right after all of us have a chance to sort of speak to some of the implications of the decision. And so really want to encourage you to answer those questions. Ask those questions. And I know there are many people who are wondering what comes next and what's, whether there's going to be settlements. Those are very common questions we've already been getting from folks emailing them in. And so so we will address, what we might expect next steps to be, but certainly do as much as we can on that in the Q&A too. So so with that, as I think many of you know, there was a decision last week on Wednesday, September 3rd, from Judge Allison Burroughs. And it was a decision where she agreed with the plaintiffs who brought two different cases. So the Harvard brought a case and the American Association of University Professors, AUP, brought a case. And those cases were heard and briefed on the same timeline. And so the decision that came out from the judge last week addressed both of those cases. And Judge Burroughs agreed with Harvard and the AUP that the federal government deciding to slash more than $2 billion in funds was done in retaliation for Harvard's decision to fight, to try and to file a lawsuit to push back on the federal government's efforts to try and take over a wide range of functions at Harvard. And so the court found that they had acted in retaliation of Harvard's attempt to fight and efforts to fight. and secondly found that most of the reasons they tried to change their tune. We'll talk about that in a little bit, but a lot of the reasons why the federal government had stated that they were coming after Harvard is because Harvard hadn't addressed anti-Semitism sufficiently on campus. The court found that a couple of things about that. One is that in trying to actually investigate anti-Semitism, which they didn't have any kind of investigation or findings or process here, that they hadn't actually followed the process that was required under Title VI of the Civil Rights Act of 1964. And Title VI protects against discrimination on the basis of race, color, national origin, and certainly the anti-Semitism is considered under Title VI, and the court found that they hadn't actually followed any of the procedures that they were supposed to follow before deciding all of a sudden to cut off funds. And so it was also a violation of the procedures and process under Title VI. And a lot of that goes under something called the Administrative Procedures Act. The last part of this is that the court found that the actions that were taken by the federal government were arbitrary and capricious, because the reason that they gave, which is they wanted to combat anti-Semitism, had nothing to do with what they did in this case, which is to slash billions of dollars in research funding, ending up hurting a lot of people, the livelihoods, the efforts to improve and save lives that are happening in research institutions all across the country affiliated with Harvard. And so the court found that there was no reasonable explanation or any kind of relation between anti-Semitism and what actions and tactics the federal government has used here. And so for all of those reasons, the court has put into place a permanent injunction that basically says the freezing of funds that took place in April, May, and on many occasions since then from the federal government, that freeze has been lifted. We haven't yet seen any money flowing, so that is something to certainly be concerned with. But that freeze has been lifted, and it can't be reimposed according to the court's decision, because the very basis of it is a problem under both the Constitution and federal law. So with that, that's my very quick summary of the decision. But I want to turn to the three people who are joining me on screen, and I'm going to do a very quick introduction of all three of them. Corey Stoughton has been counsel for the American Association of University Professors in the case. I had the real honor of being able to watch Corey argue this case in federal court in front of Judge Burroughs, and the victory is very much to AUP and their efforts to make sure that their members, and I'll have Corey talk about that, are protected in all the ways that the Constitution and certainly federal law provides. And Corey and I both share many origin stories, including being at the Justice Department, which is where I also am here with my colleague, Whitney Pellegrino. Both of us were in the Educational Opportunities section of the Civil Rights Division of the Department of Justice, where our jobs were to do investigations of civil rights laws like Title VI, but to do them in the right way. And so I'm really grateful that Whitney, who not so long ago was at the Justice Department earlier this year and has come out and has been advising institutions around the country, to have her join me, because she's one of the few experts in how this all is supposed to work. And then really honored to have Ramya Krishnan here with us, who is part of the mighty team at the Knight First Amendment Institute, and they have been instrumental in multiple cases around higher education and the First Amendment and freedom of expression. And so we all have different things that we're bringing to the table, but honored to have them here. And with that, I'm going to ask all of you to talk a little bit about sort of what emerges from this decision in your mind, and in terms of the kinds of areas that you've really focused on. Corey, I'm going to start with you, because obviously you probably know this better than all of us. So I want to just turn to you, and then I'll turn to Whitney and Ramya as well.
Yeah, thanks, Anu, and thank you everyone for being here. This victory really belongs to the faculty, both AAP and the United Auto Workers, who represent the non-tenured faculty, many of the non-tenured faculty and researchers at Harvard. And I always like to make sure that people know, and I think many of you do know, that actually it was the faculty that sued first before Harvard stood up to the administration at a time when no one was really sure that Harvard would. And just as they did at Columbia, with unfortunately less great results, AUP and the other unions, stood up and sued because what was really facing them was a threat not just to the funding programs, which are horrendous, but a threat to academic freedom. And what was at stake was it was obviously the billions of dollars in funding, which were funding critical programs, and I think it's important to say that some of that harm was done and can't be undone. I mean, I know that we have clients, members of the unions, who have lost their jobs already or who have lost critical jobs within their research projects, funding, which caused harms that just can't be recouped even if the money does get turned back on. And I know that there are really important programs around, gathering genetic data information and database, kind of large databases of genetic material that had to stop. And it's not really even clear that they'll even be able to start back up again. But it's also true that winning this victory is probably going to save a lot of incredibly critical research and programs that have been gathering data and samples for decades and building long-term studies that are critical to public health issues, critical to American competitiveness, and to future exploration of space and other things that we all value really dearly. And that was at stake, but I think also at stake was academic freedom because it wasn't just the funding cuts that were the problem, it was the conditions that the government was placing on federal funding, on the retention and future ability to get federal funding that really terrified the faculty and the students and everyone who cares about higher education. Some of the demands that were made public in some of the letters that came out in the Harvard litigation were to subject entire departments to audits based on viewpoint diversity from the perspective of this administration, which I think everyone rightly feared wasn't really about diversity, but was about ideological slant and whether it was perceived to be sufficiently aligned with the administration's political views. And, those kinds of demands about how protests and speech are regulated on campus, not just in a nuanced way about whether there's, threats of violence or intimidation to particular groups of people on campus, including Jewish students and other members of the Jewish community, but restrictions on lawful protest on campus, things that really go, reviews of curriculum. And of course, some of the things that were pressured are things that unfortunately Harvard has already agreed to do, like disbanding DEI programs and reforming certain aspects of the student discipline system. And so we knew that that kind of coercion was having an effect already, and the faculty and Harvard community and the students were already feeling that. But the really, if I could use the technical legal term, bananas conditions that the administration placed on some of this funding took it outside the realm of any kind of reasonable reaction or reasonable response to anti-Semitism and really threatened the heart of academic freedom and free speech. And so that was what was at stake. And the decision was a resounding rejection of that approach, which I'm sure we'll get into more detail about. But as Anu, talked about it, it really, we won on all of the arguments. We won that it was a violation of the First Amendment, both because it was in retaliation for Harvard standing up, but also because it targeted those academic freedom principles and free speech principles and threatened them, that it was coercion in violate of Harvard using the threat of federal funding to get Harvard to do things that the government could not directly regulate without running foul of the First Amendment. And also that they didn't follow the Title VI procedures when they said, well, I will say they said they were enforcing anti-Semitism, but they also said a lot of other things, like that they didn't like that Harvard had remedial math programs, allegedly, or that Harvard's admissions process was, skewed based on race, and a range of other grievances at various times that made it really clear that it wasn't just about, it was never really about anti-Semitism. And then, of course, winning on the arbitrary and capricious claims under the Administrative Procedure Act, which, for those of you who are non-lawyers, really just means that the government didn't have a rational basis for what they did, or didn't kind of lay out in a rational way its decision making. And that's kind of that erratic kind of, the bananas factor, if you will. So it's really great to see that, and I'm sure we'll talk. I'll stop talking there. That's a good way to kick off, and we can come back to talking about the consequences. And I know there's a lot of questions about what comes next, which we can talk about too.
Thanks, Corey. Winnie, I'm going to turn to you, and I think it would be really helpful to talk about the ways in which this is supposed to work, and how these kinds of investigations have been so incredibly important to upholding the rights of so many of students around the country, and faculty and staff as well, and sort of what happened here.
Sure, thanks so much. I think one of the most disheartening things about leaving DOJ and about what's happening now is that there were so many important parts about how the government worked with federal funding recipients to secure compliance, to protect students, to protect employees, and the commitment to do that while being mindful and compliant with the First Amendment, and respecting and understanding that institutions have a lot of other obligations that they balance with their civil rights obligations. And so the idea that an institution has to choose between combating anti-Semitism and respecting the First Amendment, or institutional autonomy or academic freedom, like, that is just a perverse understanding of what the government's role is and what Title VI means. So for my years in the government, I was there about 18 years and did dozens of investigations, many under Title VI, also under Title IX and our equal protection jurisdiction. And I think the main theme was, you went where there was actually a problem. You didn't go looking to find a problem at an institution that you wanted to target. Like, that's just not how Title VI enforcement works. And so there's lots of ways that we would get investigations. We would get complaints. We would see news coverage of things. We would meet with advocacy groups and community organizations to hear what was happening at institutions. And then we would engage with the institution about what was actually happening on the ground. And I think one of the things that really stood out about what happened at Harvard, and what I think is happening fairly uniformly across the country, is that what is happening doesn't actually matter. That is not relevant to the ultimate determination about whether there's been a violation, what demands will be put on the institution, and what the terms of keeping their funds will be. And so I think here, where you had an institution that wasn't perfect and had things that needed to be worked on, and had a demonstrated commitment that it was engaging in that difficult work of trying to live up to those obligations, that none of that was considered as part of a determination about whether there was a Title VI violation, setting aside the fact that then they also didn't go through any of the procedural mechanisms that were required, and we can talk about that. But for the most part, at least when I was in the Civil Rights Division, we rarely got to those later steps of the procedural mechanisms, because so much work happened in the discussion about what was actually happening on the ground, and how to bring that institution into full compliance with the idea that if the institution is a partner in that plan, then that is true institutional reform, and that the benefits to students and employees will live on when the government is gone. And I think it's clear here and in many other situations that those are not the goals, and that is why that's not how it's being approached. And I think what's great about this decision is it brings schools back. It tethers us back to the law. I think institutions, the schools that I'm talking to and the general counsels that I'm working with, feel untethered. Like, they do not know what are their guiding principles. And they feel like very vulnerable, that without those guideposts as to what they're supposed to do or not do, that basically anyone could be targeted for anything at any time. And I think it's really important that this decision went back to Title VI and said, no, actually Congress said what's supposed to happen if you're trying to combat anti-Semitism or other violations under Title VI, this is the statute that tells you how to do that. And these are the procedures that govern that process. And you can't disregard those and essentially put a gun to an institution's head for some other purpose. So.
Thanks, Whitney. Ramya?
Yeah, I mean, I think this was a really important victory, not just for Harvard, but for other higher education institutions as well. And it's not even just higher education, because this is really, I think, should be seen as part of the administration's broader campaign of extortion to scare civil society into submission. The court's First Amendment holding, I think, was particularly important in a variety of ways. I mean, I think the most important sort of thing that it recognized here was that although combating anti-Semitism is, of course, an interest of the highest order, that interest was invoked here as a pretext for going after higher education and undermining its institutional independence and its academic freedom. And I thought the court's analysis here was really careful, and it pointed to sort of a number of facts which belied the administration's purported, concerns about anti-Semitism here. For starters, it noted that most of the demands that the administration was making here had nothing to do with anti-Semitism. They were things like shuttering DEI programs, hiring faculty and admitting students to achieve the administration's preferred ideological balance, things of this nature that really had nothing to do with anti-Semitism. In addition to that, the administration hadn't bothered to sort of gather any data about anti-Semitism at Harvard. It didn't consider the value of the grants that it was ending, and it didn't consider whether terminating any of this critical research would actually help Jewish students at the university. The administration, as the court noted, disregarded the policy and other changes that Harvard said that it had put in place to address anti-Semitism. And the final nail in the coffin was the administration has been very public about what the reasons for what it is doing here. And again, you've had the president, the Secretary of Education, other high-level officials in the administration making clear that their motivation here was ideological and it was not actually about ending discrimination. So that, I think, is an important conclusion. And the court recognized, as Anu and Corey noted, that what the administration did here amounted not only to unconstitutional retaliation, that is retaliation against Harvard for its decision not to accede to the administration's outrageous demands and to protect its institutional independence, but also unconstitutional coercion, because as the Supreme Court has recognized, the government is foreclosed from doing indirectly what it is forbidden from doing directly. And so here, the administration is using funding cuts, the threats of funding cuts, in order to suppress research that is, undoubtedly protected by the First Amendment. Decisions by Harvard about its governance, about its hiring, admissions, all of these things are considered absolutely essential to the exercise of academic freedom by universities in this country. So yeah, I think the court's First Amendment holding, but also holdings on these other issues are important, again, not just for Harvard, but more broadly.
Totally agree. And I think the protection, and it's really important to just say it again here, which is that there is a protection for Harvard fighting in this case, right? Standing up. And I think in this moment where we are in America, where so many are being threatened by the federal government with takeover, with coercion, with all of the kinds of massive billions of dollars in pressures that are being placed, a court decision that that really emphasizes that that the fight itself is something that you can't punish someone for. And so I think that's another really, there's lots of ways in which the judge has been really helpful here in terms of going through what's at stake here, right? And I think the judge did a really nice job of talking about what's at stake, and clearly that there was no consideration of that in the kind of actions that are being taken. And this is just a government that is trying to impose its own agenda in ways that don't even follow the law. So I wanted to ask all of you about what does this mean for other educational institutions around the country in this moment? I know we're all, in different ways engaged with other educational institutions. What would you say to them about this decision? What was your reaction last week? What advice would you give for those who are similarly being threatened, who are in the middle of these kinds of really thorny and challenging times where much is at stake, as the court said here, and you have a government that sort of bypassed the usual practice. So let me just ask all of you to talk a little bit about that. Feel free to go in whatever order works.
Well, I'll start. I mean, I think before the Harvard decision and after the Harvard decision, the universities are in a really tough situation. The reality is that the government has enormous power and an incredible array of tools to attack higher education, and they are using them all. And I think before the Harvard litigation, the federal funding and holding federal funding hostage in a lawless manner for this range of grievances was very much a tool that was at the administration's disposal to go after every university in America, and it was using that. And I think now that tool has been blunted, but not taken off the table. And I think we have to be honest about that. A lot of the questions I know are about Harvard and whether whether they will settle. I will tell you that I have the same question. I think this is clear, but I don't represent Harvard, the president and fellows of Harvard. I represent the faculty, and the faculty have not been negotiating with the Trump administration. It's the president and fellows that have been. And, on the one hand, obviously, the ruling takes the winds out of the sails of Harvard's need to settle, but not entirely, because the ruling is not a guarantee of future federal funding, and there's no real legal way to compel the government to give Harvard future federal funding, or for any university to do that. And as we've seen, there are just other ways that the administration can go after universities. So if buying peace is possible, one can understand why universities want to do that. I think there's a real question about whether buying peace is possible with the Trump administration. I think some law firms have had experiences that cast some doubt on that. But if it is possible, one can see why they'd be thinking about it. And at the very least, I think all of the universities that have been facing these kinds of pressures now have more bargaining leverage. I think that's at a minimum true, and it's important. And they have more ability to resist to blunt that tool of abuse and unlawful abuse that the administration was using. So I think that's an important change, and I hope that it's put some wind in the sails, because we know that this is happening all across the country. We know it's happening at Northwestern. We know it's happening at UCLA. We know it's happening at UVA. We know it's happening in many, many places, and hopefully this will shift those dynamics significantly.
Whitney, Ramya, any thoughts out of the last week and what you've been hearing from folks and implications for other educational institutions?
I mean, I think I mentioned this before, but I do think it's important to start with the fact that Harvard was actually trying to respond to anti-Semitism. It was not denying that that's an issue that it needed to take head on, and that it could have done more about. And I think, when I'm working with institutions, I really do start from the place of like, let's talk about what you're doing to respond to the real civil rights issues that your students and employees are facing, because that is actually your best defense. You're not to Corey's point, like, I'm not sure that there's any amount of cooperation or engagement that will ultimately lead to a settlement that is focused on civil rights compliance. But actually complying with your civil rights obligations gets you a lot of the way there. And it puts you in a position, as Harvard was, to be able to say, okay, of these demands, yes, these are ones that we agree are important and related to the, to civil rights compliance and to combating anti-Semitism. And these other things are not. And I think creating that record for an institution about what they're doing and how they can meaningfully engage with the government about what they're willing to do, I think that helps courts draw that line between what is within the bounds of Title VI or under the APA, like what the government can ask institutions to do, and what things are just extra legal and, essentially, as Ramya and Corey said, coercion and unconstitutional conditions on participating in federal funding programs. So after that point, I think the next thing I would say is you're not going to be able to hide from this. And so you need to think about engaging with your faculty, your staff, your unions, your students. Like, the government would love to pit all of those entities and groups against each other, just as they're trying to pit all of the rest of us against each other. And so I think trying to open up communication across those lanes and talk about things that are important to both, like academic freedom and autonomy, for professors and what they're teaching and what they're talking about, and to affirm the importance of those things so that your clients, the institution's clients, actually know that they have something in common that they're fighting for.
Yeah,
Go ahead, Ramya. I was going to say, I was going to start to go ahead, and then I'll bring in some of these questions because we have a lot of extraordinary questions that have come through.
Yeah, I'll keep it short then. I agree with everything that has been said. I know that a lot of universities are wrestling in good faith with what to do here. They're between a rock and a hard place. There are seemingly no, good options. That said, the path that should be untenable to universities whose very mission is to produce expert knowledge for the public good, to prepare students for democratic citizenship, is any kind of settlement that sacrifices academic freedom, and that sacrifices their ability to decide who gets to teach, what they teach, how they do it, and which students to admit. And I think that universities need to be really clear-eyed about that when they are making a decision about what to do here.
Thank you. All right, I'm going to do a really rapid fire, and then I'm going to maybe what I'll do is I'll answer the easier questions and then really fast, which is a bunch of them, and then I'll make the harder questions ones that we all have to try to grapple with. There are a lot of questions.
Thanks.
Here we go. I'm gonna try to look like I have something to contribute here, but there's a lot of questions about what's the next steps in the case, and I just want to quickly say the federal government has said that they will appeal. They have not done so yet. We will see when that happens. There's a number of questions about what we think the Supreme Court might do in this case, and sort of how it might get to the Supreme Court. Unfortunately, I think I can speak for all of us on the screen, which is that some of what we've seen in terms of how cases are getting to the Supreme Court as part of what we call the shadow docket is, there are a number of things that have gone up and the Supreme Court has ruled on without briefing. And so we saw that yesterday as well, in terms of, how ICE can conduct some of its operations. I don't know, whether the administration will try to take this up to the Supreme Court in short form. There are other cases around NIH funding that have recently gone up to the court in that way, and so we'll see what happens. But as of now, we have not yet seen an appeal. And I think, I'll say this about the appeal process, which is I think Judge Burroughs put out as comprehensive and thorough and considered and grounded in law opinion that she could in the case, and really comprehensively look through the record. And so we'll see what happens. And then the other question, of which there are many and really heartfelt ones from people who are researchers within Harvard and in other universities who've had their funding cut, that we don't know when the funds might be released, and there are concerns that DOJ and others within the government are blocking funds even when there are court orders to disperse funds. And so the answer of like when it is that these funds might be released, and how could you, how can you actually, perhaps it'll go to Judge Burroughs or someone else to order the court, and then it'll be a more direct order to release funds. But we certainly have a lot of concerns, as many of you have put into the Q&A, about the fact that funds have it's not like the funds that have been held or even future funds are flowing as of yet. But I don't think we have any more magic ways in which to get that to happen.
I can add just a little bit on that, just to
Yeah.
say that we are actively working on that right now. The government has said publicly that they want to appeal, but they have not yet filed a notice of appeal. They also have not yet filed what they have filed in many other cases, which is a application for a stay of the judgment. And it's the stay that actually would create the vehicle for this case to get to the Supreme Court quickly on the shadow docket in a way that I'll just say is unattractive to many people. So that hasn't happened yet, though. So the order is in effect, and we are working at. I mean, I wish I could say more, but I just want you all to know that we are. I literally today, other than doing this call, spent most of the day working on this issue and trying to ascertain the government's intentions and get them to move on this. I can tell you that the government has distributed the judge's order to the government agencies that distribute the funding, so that's good. I mean, that's normal. I mean, Whitney, those of us who work in government know that that's just normal and what should happen. But in this timeline, what's normal often comes as a pleasant surprise. So that's a good sign. But of course, I don't want to be naive and suggest that it's going to be an easy road. And for those of you who are researchers at Harvard or faculty at Harvard, if you hear anything one way or the other, please get in touch with me, with your AAUP or UAW representative. You may have an email from Drake Reed from my team or another member of our litigation team. Please, please let us know, because we are trying to keep our ears to the ground as much as possible.
Great. A couple of other questions just about what are the ways in which I'm going to ask a broad question, like what are the ways in which the communities of alums, of students, of faculty, what are the ways in which people can engage right now in terms of their own institutions within even the Harvard community to try and move things forward here, given this decision, and obviously some of the things we just talked about in terms of trying to make sure that the damage that has already really been felt is addressed. Any thoughts on that one?
I mean, the alumni of Harvard is very important to Harvard. And so it's important that alumni have their voices heard on this. If it's really important to you that Harvard not settle, particularly after having this legal win, even in the face of uncertainty about what's going to happen in this case going forward, I would say make that known, both individually and if there are opportunities to do that collectively through any particular associations that you're a part of. That's an important channel, I think. If you are currently employed at Harvard in any kind of capacity, whether as a faculty member or as a staff member, please join your AAUP chapter. You're doing incredibly important work to defend academic freedom, both at Harvard, obviously, but also nationally. And really, this attack on higher education is national, in terms of its scale.
Yeah, and we're going to have both from Crimson Courage and from Democracy House folks talking about the ways in which, certainly alum communities and many others can engage. I think the question of like sort of how can we have this decision be a resource, a tool, something that we can wield in this moment as when it's been again like as a way to really shore up support and the spine of many who have a lot of pressures on them. And so I think it's part of the reason we wanted to do this, which is to get people to realize that there's a lot here that's comprehensively important, not just for Harvard, but for educational institutions around the country who are, trying to weigh their options. And so really we hope that you can all use the opinion. We can drop the opinion and the docket in the chat, but just to use that in whatever way you can. I think that, let me just ask that, Corey, I know we talked a little bit about the settlement conversation. I do think this question of all of the different threats that educational institutions are facing. So to be clear with everyone here, this decision only addressed the administration's slashing of funding for research. It did not address the ways in which they've come after international students and scholars. It does not address the threats to on endowment taxes, on tax exempt status, on pretty much we've seen like I think it's in the more than 17 or 18 ways in which Harvard has been there have been attacks on Harvard by the federal government. And then, of course, we've seen different kinds of attacks at educational institutions around the country as well. And so the funding piece has been certainly essential to this, and because you're seeing part of what we saw in this case, which is that the funding had absolutely nothing to do with the thing that Harvard said it was. I mean, that the federal government said it was worried about. It was an important way in which to fight this. But I do want to be clear, as there are a number of questions about what's going to happen in some of these other contexts, that this is not a decision that addresses them. Though I think the court's reasoning here, which is that that the administration is coming after Harvard and using tactics that really don't have any kind of basis or reason, or and they're not taking kind of what the impact of it is. And I think those things are important. And the fact that they have not gone through any kind of process that they're supposed to go through under Title VI means that all these anti-Semitism investigations, all the sort of DEI investigations that they're doing around the country, that they need to go through a process for them. And that's, they can't just completely decide tomorrow that someone's their enemy and take away funding based on Title VI or based on based on some behavior that took place without any kind of process around that. And that's an important part of the decision too.
Yeah, and I just add, I saw there were some questions about like student voices and students' experiences with anti-Semitism and how did those factor into all of this, if at all. And I would just say like that sort of goes back to the original point that like what the government is supposed to do is conduct a robust investigation, to talk to students, to talk to employees, to gather all of that information and then figure out, okay, was there severe and pervasive harassment? How did the school respond? Were they deliberately indifferent? How, what are all of the things that they put in place to protect students? And then to the extent there are still problems, what does the institution need to do to address them? Because that didn't happen, Harvard has engaged with students and I think has done a lot of that work on its own, but it wasn't through the course of the government's investigation, which is traditionally how you would marshal those stories in determining whether there had been a violation of Title VI. So, I think that's sort of what I was saying for institutions, like do that work yourself. If the government is not going to actually use its power to understand students' experience, understand faculty's experience, and try to solve those civil rights issues, then institutions should be doing that, because that will be, one, the best way to make sure you're taking care of your students and your employees and your climate, your civil rights obligations, and your best way to defend that you've done that work, even if the government doesn't do it.
Yeah, and thank you for that, Whitney. It's and just on the particular part about Harvard settling, look, there's been a lot of rumors. I feel like every week of the summer there was some rumor about Harvard settling, and we were trying to figure, and everyone's trying to figure it out, and it was like, you know, it'd be like the media is asking the council, and the council is quoting the media, and the media is quoting the alumni. I mean, it was like a whole mess, right? And so the answer is none of us really have a sense of where things are at. This decision was certainly, I'm again, I'm going to say it over and over again. Gratitude to everyone who has stood up in signing letters, signing petitions, making your voice heard, writing letters to the administration, doing whatever you can do, because it is actually a really monumental moment that this decision this is one that Harvard fought, but there's a decision that came down before there was a settlement. I think it's really important to have this decision, no matter what happens next. It's really important to have this decision, really, as Whitney said, bringing back the law into this conversation, because in so many ways, this administration has not been acting in a way that it just kind of assumes it can do whatever it wants. And so it was important to have the decision come down before that took place. And so the question of I'm hoping that this means that Harvard has a different kind of seat at the bargaining table, and we'll see what happens. But none of us here have as Corey said, we all have the same question. Let me some of the other questions that are here are about there's a lot about sort of what recourse that Harvard and other educational institutions will have. I think there's also some questions really about where we are in terms of academic freedom writ large, and I don't know, one of the things to just underscore here is the ways in which the court really spelled that out, and so I don't know if anyone wants to talk to that a bit more broadly. I'm trying to go through and see what other questions I can pull out that we might have an answer to. But anyone want to speak to just sort of what academic freedom means in the legal context and the ways in which the court, I think there's really good language from the court on that.
Yeah, I'm happy to start there. Yeah, I mean, academic freedom is crucial, as the court recognized, and as the Supreme Court has recognized in a previous case from well over 50 years ago. Academic freedom really comprises for the university for things, and I mentioned these earlier, but the right to decide, who teaches, what they teach, how they teach, and which students to admit. And the Supreme Court has previously characterized those freedoms as essential to what universities are and the role they play in our democracy, especially the role that they play in educating young people and preparing them to be citizens in a hopefully flourishing democracy. So that's why courts have recognized that academic freedom is of special concern to the First Amendment, and also that faculty have, of course, their own academic freedom rights here, both in terms of what they choose to research, how they choose to research it, the ability of departments to self-govern, and the ability to decide what to teach in the classroom within the parameters of sort of disciplinary practice and expertise. So without academic freedom, universities can't function as we sort of know them.
Yeah, I would just add to that. I think that one thing that's really important about the Harvard decision is the decision on standing. So this is the doctrine of like who gets to sue, who has the right to sue. And one really disappointing thing that happened in with Columbia is that when the faculty stood up to sue, unfortunately, the district court in New York, the judge there dismissed the lawsuit on standing grounds and said that basically the faculty were not could not come to court and complain about what the administration was doing to to Columbia, because it was really a dispute between Columbia, the administration, and the Trump administration. Columbia's administration, the Trump administration. And I think that was, that was such a horrendous moment. I mean, it's a terrible decision and a really horrendous moment, dispiriting moment for faculty around the country, because the court was essentially saying we're going to cut the faculty out of this conversation entirely and not give them any mechanism to go into court and vindicate those important rights that Ramya just talked about. And even we had to work really hard to get that decision in this case. Harvard, the corporation's standing was never in question, and the government always said that we should go away, just like the Columbia faculty had to go away. And even the day when we stood up in court to argue it, the first thing the judge said is, why shouldn't I just rule in the Harvard corporation's case and stay your case and not deal with your more complicated standing issues that you raise? Which the result of that would have been to get a ruling just for Harvard, but not for the faculty. And that would have been really difficult for amongst other reasons, because then the faculty wouldn't have an enforceable judgment. And if Harvard did decide to settle, and particularly if they decided to settle on terms that were horrendous and an attack themselves on the faculty's academic freedom, the way that many people from Columbia feel that Columbia did, we would not have had a court order to enforce. And so we had to, for those of you who were there, I spent quite a lot of time in court that day trying to explain to the judge why she shouldn't do that. And thank goodness she heard that. And boy, did she. I mean, the ruling on standing is a very strong one. And I think it should embolden and help support any other faculty at other universities whose faculty unions want to step in and take that stance to make sure that they have the ability to get in the courtroom door on that. That's because, there's substantive rights, but then if you don't have procedural rights, you can't exercise, protect your substantive rights. And standing, as we've seen across the board in a range of cases involving the Trump administration, has been one of the ways that courts, including the Supreme Court, have really brushed aside efforts to challenge some of the more egregious abuses of power.
Thank you. Before I turn it over to Naoka Carey and Amber French from Crimson Courage and Democracy House, I just wanted to end with actually some of what the court said, in what Judge Burroughs said in her decision, because I think her last couple of pages are pretty powerful. And so I'm just going to read 3 lines and then I'm going to turn it over. The first is about, she talks about free speech, and she says, free speech has always been a hallmark of our democracy. Supreme Court itself has recognized that efforts to educate people, change minds, and foster tolerance all benefit from more open communication, not less. And a few sentences after that, says very clearly that combating anti-Semitism cannot be accomplished on the back of the First Amendment. And so, again, recognizing what's at stake here, and also that this is not the way in which to address the kind of concerns that are coming up. But her last line of the opinion, which is an admonition to courts, but I think it's also something for all of us to keep in mind, which is she talks about, her last line is, now it is the job of the courts to similarly step up, to act to safeguard academic freedom and freedom of speech as required by the Constitution, and to ensure that important research is not improperly subjected to arbitrary and procedurally infirm grant terminations, even if doing so risks the wrath of a government committed to its agenda, no matter the cost. And so I think it's not only the job of the courts, it's the job of all of us. And with that, I'm going to turn it over to my lovely friends, Naoka and Amber, to close us out. One last note before I do that, Richard Lempert, a legend in higher education, was in the chat talking about how we need to go appeal to our congressional Democrats. I will always back up Professor Lempert on this, but also just say we have to really speak to our congressional Republicans as well. And in the case of Harvard, we found it today, there's 51 members of Congress that have some kind of Harvard affiliation. So let's go on that and every one of the other affiliations that are out there. So Naoka and Amber, take it away.
Sure. Amber, do you want to start or?
Yeah, well, so first of all, that was amazing. Thank you all so much. The key to any organizing effort is celebration and also acknowledgement. So everybody who's on the call, please join me in just thanking Corey, Whitney, Ramya, and Anurima for that incredible presentation. Thank you. Love to see the love in chat. I'm Amber French. I'm Executive Director of Democracy House. So thrilled to be able to co-host this webinar tonight with our amazing friends at Crimson Courage. And also just really appreciate seeing all of you show up. It's been an incredible outpouring of support over the last week from young people, students, alumni that we're working with, and just really, really incredible to be with you all here tonight in community. I think our colleagues will be dropping the Democracy House and Crimson Courage websites and links into chat as well. And Nauka, close us out.
Sure. Thank you so much. It is just such a joy to hear from such brilliant women and attorneys about what's at stake here and what this decision means. And so I hope you all feel a little bit inspired that fighting sometimes means we win and that sort of has big impact. So that's the first thing. I also just want to echo, because I know a lot of people are asking, what can we do? And so I know people are coming from a lot of different parts. I'm part of Crimson Courage, but a lot of you are coming from other universities and work with other universities. So just first, you can, whatever status you are, whether it's an alum or a student or somebody who's just affiliated in other ways as a faculty member or as a parent, you can reach out to the universities you're in touch with and just let them know that academic freedom really matters and that they should be standing up for it wherever they can and in whatever ways that they can. But also, Amber and I both work with organizations, both Crimson Courage and Democracy House, and working together are hoping to pull together sort of more organized responses to that. So we definitely urge you to look into our groups to try to get engaged in some of that more collective work. And you've certainly heard about the collective work of the AAUP tonight too. So there's lots of collective opportunities, but also individually you can all do stuff. So we encourage you to do that as well. So, and thank you again to our panelists. You are all incredible. It's really great to hear from you. So
congrats to everybody here on the win. It's everyone's work and it's everyone's doing. And it's really important that we celebrate the wins and we keep fighting with those wins in hand. So thank you all for coming and thank you for listening in. Really appreciate it.